Today, former President Jacob Zuma will face off against State Prosecutor Billy Downer and legal journalist Karyn Maughan in the High Court sitting in Pietermaritzburg. So Zuma opened a criminal case against Downer, who's the lead prosecutor in his corruption trial. He claims Downer leaked his doctor's note to Maughan, saying this amounts to a breach of the NPA Act. Meanwhile, Maughan is fighting back to have Zuma's application rejected, saying this is an abuse of court processes. At the same time, Media Monitoring Africa is also seeking to offer expert input to the courts. Let's make sense of this for you now. Bring in the body's Executive Director, William Bird. Also joining us is legal analyst, Mpumelelo Zikalala. To both our guests, good morning once again. Thanks very much indeed for making time to chat to us. William, let me begin with you as a start. I mean, what does expert input mean? Can you explain what your involvement will be in layman's terms?
Good morning. So one of the things that we've done on a number of occasions, and in fact on this occasion it's the Campaign for Freedom of Expression, South African National Editors Forum and Media Monitoring Africa are going to apply to join as an amicus, which is a friend of the court. And what that means is that we, because of the work that we do, the areas of knowledge and expertise that we have, we're able to bring things that perhaps will aid the court and assist the court in coming to a decision. So we're not entering for either side. We are entering because we think that there are particular points of law, particular areas relating to this case that we think are especially relevant. So, for example, one of them is around this idea of a slap suit. And a slap suit is basically a legal process that is used around the world in order to try and silence journalists or silence public participation. So very often big corporations or those with power will use it to try and stop an entity from saying something. And we believe that there are relevant elements of slap suits in this particular case. And so it's being able to bring different arguments and information to the court's attention to help them make their decision.
That's an interesting take, especially because you're saying you're not necessarily taking either side. Does that mean, hypothetically speaking, if there's information, say, from the former president's legal team that would aid them in this court, you'd be open and available to assist them in that way?
So really it's about the nature and knowledge that we bring and the expertise that we bring in, because all of these bodies are freedom of expression, have expertise in freedom of expression, in understanding the media sector, in understanding attacks on journalists, for example. That's where it lies. So it doesn't lie in for example, in the NPA Act or criminality per se, but it does lie in understanding and looking at constitutionality issues around, for example, sections of the NPA Act, or around issues like attacks on journalists, which is another key thing that we wish to highlight.
Yeah. Mpumelelo, let's bring you into the discussion. There are multiple moving parts to the story. In fact, I think at least 3 applications. One against the former president, against Billy Downer, one against Billy Downer. The former president against Billy Downer. There's one where Billy Downer pushes back against that, and Karyn Maughan has also put now an urgent application arguing that this is an abuse of court processes. How do you reckon today will unfold? Because on the face of it, it almost seems like these issues can't even be on the same court roll.
You're quite correct. Even on the forums in which they've been brought into, I think one of them will have to forward before the other one proceeds. Let me explain why I say that. Let's start with the urgent application. When you bring an urgent application, you're basically saying to the court, I have an interest that I need to protect urgently. I'm going to suffer irreparable harm if I'm not granted the relief that I seek today. And there are no other alternative remedies that are there. So before you even decide the merits of my case, please deal with opening the door for me so that I can explain to you. Now, with this application by the journalist, Ms. Karyn Maughan, the one thing that I may find a bit of a problem with is the alternative remedy which is available. Just remember, the Section 106 of the Criminal Procedure Act is exactly the type of section that you invoke when you then say, this particular individual does not have charge to prosecute me due to other things or other elements that are there. If you want to bring in other stuff, maybe you can come back and say, let's do a normal application without the agency in it, and then the court will be able to entertain. But the most important question which the court is going to ask is, what have you been doing since the day that you've received summons up until now? Are there any instances in which you have caused self-created agency, or is it such of importance that your matter must be dealt with today? If that particular agency is dismissed, by the way, it doesn't mean that the matter ends there. They can still go on, but on the normal roll now, so that at the end of the day, they're able to hear the matter in a normal court and scope of how the court would operate. As you correctly stated, there's then a second element, the one dealing with Advocate Billy Downer in terms of his application. Now, let's take this one as a pre-trial conference or pre-trial proceedings in which the court will then come in and say, is this issue of security that we have to discuss? The Criminal Procedure Act under Section 7 to 18 deals with security and how it should be paid. One is asking for security which is exorbitant. I, as the court, as the final discretion maker, all have the final discretion. Let me decide which security amount is appropriate before we move on, before we deal with the nitty-gritties of saying who are the witnesses, when can they come in, what are your diaries, gentlemen, so they can be able to deal with the matter once and for all. So for today, I think for me it's all the housekeeping issues which are going to take place and deciding whether the agency will proceed or not.
Yeah, and of course, it shouldn't be lost to us that at the heart of this is, whether or not this corruption trial, this arms deal case, which is decades in the making, will ever get underway. From your vantage point, Mpumelelo Zikalala, do you reckon there's no way that trial can continue until this moment is put to bed? And there's no telling how long this will take.
No, it can continue. Let's separate the two. Let's remember that the trial is waiting determination by a higher court. That's the only thing which is stopping from proceeding. Now, if you then come back and say, I can't prosecute, or this prosecutor can't prosecute me because I have a certain matter against him, the court is going to come back and say, show me a provision in the Criminal Procedure Act or that is in the interest of justice, any principle that is there that says that you can't prosecute if the prosecutor is being prosecuted by you in another matter. If you want us to decide this matter again, bring a fresh application with all the points that are there dealing with the charge to prosecute. Let's remember that the case at N Division is pronounced on this as per the judgment of Judge Kuhn in terms of saying, charge to prosecute simply means to me as the court, administratively, do you have the papers that allow you to stand in front of me? If the answer is yes, then let's proceed. So I don't think the two are going to be in conflict. Both of them can continue at different times. You don't need to stop so that you firstly exhaust another before you continue with the other one.
Interesting. William Bird, some people will say at the heart of what's actually said to be ventilated in court, at least with this leg of the wrangling, is around whether or not the former president's doctor's note was made public before it was reported on. What kind of questions do you reckon the court needs to ask around that particular issue? Because this is why Karyn Maughan was even dragged into this to begin with.
Yeah, I mean, the Zuma's campus, it has interestingly shifted the arguments that they made in public to the ones that they finally presented in court in terms of what those issues were. So initially their argument was that this was about the fact that she had in her possession a document, whereas in fact it's very much about disclosure. And what certainly appears to be the case, and obviously the court will need to decide on this, is that that information was only made public to the public once that document was in fact within the realms of what could ordinarily be made and determined to be public. So in an ordinary court process, once you've submitted your documents to the court, and if you can get access to them through normal legitimate means, then you can make those things public. It's precisely in the principle of open justice that things that are submitted to the court that form part of that court bundle, that those things are made public, unless of course they're unusual or special circumstances where they request that is made confidential, and then the court will determine whether or not those documents can be made confidential. Or, for example, if you're dealing with children, then the court may say, right, you can reveal this, but you're not allowed to reveal the name of the child involved, for example, or something that may identify the child. So there are lots of checks and balances in relation to this, but certainly in this instance, it's one of the reasons why we think that there are elements relating to slap suits that are so relevant to this, because certainly on the basis of what's in the papers, the information was only made public once that information in fact was available to the public. So it would seem then that there's something else that's driving this particular instance against Karyn Maughan.
Sure, and hopefully all of that will be much clearer sooner than later. To both our guests, thanks very much indeed for helping us break down what is taking place and what perhaps we should make of it. William Bird is with Media Monitoring Africa. Mpumelelo Zikalala is a legal analyst. To both our guests, once again, thanks very much indeed for your time.